So even before the bail applications could commence, suspended EMPD Deputy Police Chief Julius Mkhwanazi's lawyers argued that based on the charge sheet, the state alleges that when 13 individuals comprising of EMPD, SAPS and private security members tortured and killed Emmanuel Mbense, they decided to involve Julius Mkhwanazi, and when he arrived on the scene, Mkhwanazi hatched the plan to dispose of Mbense's body into the Spaarwater Dam, which is 23 kilometers away from the scene. Mkhwanazi's lawyers say based on that should lay the basis for him to face a lesser charge of accessory after the fact and not murder, which is a Schedule 6 offence. Well, they also wanted to be furnished with reasons why the state was opposing the bail application, which they believed should be based on the lesser charge.
It is quite clear on the version of the state that accused number 5 on their version on the charge sheet can at best be an accessory after the fact, after the murder. That is not a Schedule 6 offence. The following paragraph also says that, and deals with the robbery, bearing assault on the deceased. Others took for themselves items from the deceased premises. We should now, this is clear, also before accused number 5 would have been said to have arrived at the scene. There is no mention made in here of common purpose with accused number 5 with the others, when such common purpose was formed, because according to the state, they decided on his involvement only after the deceased had died.
The state, with the greatest respect, are playing games. They're not open and giving you a proper charge sheet. I don't want to go even through the charge sheet. It's vague and it's embarrassing. But that's their charge sheet. That's the charges or the basis and the summary the state based their case on, which they opposed this bail application. With the greatest respect, Your Worship, the fact that it's a Schedule 6, there's sufficient case law, doesn't mean the state has to oppose. They have to at least tell the court, tell us why they're opposing bail.
My little colleague Mr. Nel correctly referred to it as an application by ambush, because we don't know what we need to meet. The state says, show us your cards, we will decide upon that whether and how and on what basis we're going to oppose the application. We don't know.
The state cannot be forced by the defense to put the evidence before even they commence with what they are burdened with in terms of the law. We'll look into Section 60, all the likelihoods going down, to point out what is the state's view in as far as the likelihoods are concerned. So, Your Worship, I request with all humility that the defense at this stage, we have wasted a lot of time dealing with the issue that I think we should have tackled within a few minutes. The defense must indicate, are they willing to commence with the bail application as per the charges placed before court? Number 2, if they are not, they still will require further information. Then are they willing that the matter be remanded so that the state can look into the matter and decide whether the state is giving this information?
With the lawyer for accused number 3, Adrian MacKenzie, and accused number 4, Keisha-Leigh Stols, arguing that no grounds were furnished for the state opposing bail and that she was not ready to proceed with the bail application. Well, the matter has been postponed to August the 13th. Crisalda Lewis, SABC News, at the Brakpan Magistrates Court.